Ahamed and London Borough of Haringey.
You're both standing up. It's pretty inconvenient for us if you sit in the second row. Yeah, how long will it take you to move to the front row?
A matter of moments.
A matter of moments. Should we just rise for a second? I just think we'll give you a chance to do that because I know I'm going to be telling you to speak up.
Court as if able.
Looks like that. Oh.
Yeah.
Right.
Court rise if able.
Yes, Miss Murray.
My lord, if it please the court, I appear on behalf of the appellant. My learned friend, Mr. Evans, appears for the respondent. The court should have 3 bundles, 1 supplementary bundle, 1 core bundle, 1 authorities bundle, and in addition 2 further authorities, which I emailed to the court yesterday. I propose to insert the case of Robinson and the London Borough of Hammersmith and Fulham as tab 18 in the authorities bundle, and UO and Redbridge as tab 19 in the authorities bundle.
I would do that, only it's until punched. So this fat authorities bundle, 17 tabs, and it supersedes the earlier one. We did originally have 2 separate authorities bundles.
There should only be 1 authorities bundle which goes up to tab 17 until I added 2 further cases.
And the supplementary bundles, in fact, are hearing bundles, just so as to confuse us.
Essentially, the supplementary bundle is the yes, my lord.
Yes.
This appeal is about the interaction between the homelessness relief duty and the main housing duty under Part 7 of the Housing Act 1996. It raises the following 3 issues. First, upon acceptance of the homelessness relief duty, is an authority absolved?
Sorry, if you want us to write this down, you have to go at dictation speed. These propositions are not in your skeleton.
These propositions will structure my submission.
No, fine, sorry, then, okay, on acceptance that it's a relief duty.
Upon acceptance of the relief duty under section
189 capital B, is an authority absolved from the obligation to make further inquiries?
Absolved from the obligation under
Section 184, my lord.
Section 184 to make further inquiries.
into the application. Yes, my lord.
Okay. Second.
Second, if not absolved, what is the time frame for the completion of inquiries as to priority need and intentional homelessness?
Sorry, completion of inquiries
Into priority need, my lord.
into priority need, yeah.
As to priority need and intentional homelessness.
Those are the two tick box
They are
questions.
Yes, they are conditions which are necessary for the main housing duty under section 193 to arise.
Third.
Third, if the authority concludes that an applicant is in priority need and is not homeless intentionally and is owed the main housing duty,
Sorry, is in priority need and is not intentionally homeless.
yes, my lord, and is owed the main housing duty
Under
section 193, my lord.
yes.
What reliance can be placed on the accommodation occupied during the homelessness relief duty phase?
Sorry, what reliance can be placed on accommodation offered,
Occupied.
under relief duty under
The relief
section
duty phase.
189B.
189 capital B, yes, ma'am.
Sorry, just to be picky, I know that's how you refer to the duty under 189B. That's not the statutory term. The statutory term calls it the initial duty. Isn't it?
Yes, it does. Yes, it does.
Is the relief duty something that homelessness lawyers always use? Why are you using it rather than initial duty?
It's always referred to as the relief duty.
Okay.
We can look at the wording of it, if it would assist. I'm going to come to that.
No, don't worry, I just wanted...
There are three duties, aren't there?
Sorry, no.
There's not just two duties, there's three duties. There's 188,
Yes, ma'am.
189B,
Yes.
and 193. What are they all called? I mean, what shall we call them? So
Well, taken in those terms, section 1881 is a duty to accommodate. That's an initial duty to accommodate.
initial duty, really.
Well, sorry to be a nuisance. You may call it an initial duty, but the statute in the title to 188 calls it an interim duty.
Yes, my lord.
And I just think either we should use the statutory terms, or if we're not going to use them, we should flag up that we're using what we think are better terms.
Yes, my lord. The interim duty to accommodate is provided by section 1881. That's at page 17 of the authorities bundle.
So we'll call that the interim duty. So we have a term for it.
Yes, the interim duty. my
Yep.
lord.
We're going to call it the interim duty. And then the 189B.
Well, prior to that, my lord, if I may, at page 23 of the authorities bundle, there is a duty to make an assessment of a case and provide a personalised plan. That's section 189 capital A.
So you've got a 1881 interim duty. You've got a 189A assessment and personalised plan duty.
Yes, my lord. Then, at page 26 of the authorities, section 189 capital B, the initial duty, the one which I referred to as the relief duty.
Are we going to call it the relief duty or the initial duty?
In my submission, it should be referred to as the relief duty, for reasons that I'll explain.
Also has the advantage that the initial and interim are very easily confused.
Yes, my lord. And then there's the main housing duty under section 193. That's at page 33 of the authorities.
Well, there we are, and that's very clear.
So 4 duties, my lord.
Sorry to be picky, but when my lord said 3 duties, I think he meant 3 duties that could result in the provision of accommodation. If you're going to include other ones, like the 189A, which is the personalised plan, you ought also then to include 184, which is the duty of inquiry.
Well, yes, my lord. However, 189B is actually a duty to take steps.
I
rather
understand
than a
that,
duty to
but
accommodate.
of course, that's why I said which could result in the provision of accommodation.
Yes, my lord.
Whereas, so you've got some which what I might call procedural duties, which would include inquiry and 189A, making a plan. And then you've got substantive duties, the interim duty, which may mean they have to provide accommodation, the relief duty, which means they have to take steps to help get them accommodation, but they may end up with getting accommodation. And then 193, which is again a duty to provide accommodation. That's why I was making the distinction between procedural and substantive. Does that make sense?
Yes, my lord, that does make sense. My first set of submissions are about the exactly these duties. So the first issue I identified in the appeal was, upon acceptance of the homelessness relief duty, is an authority absolved from the obligation to make any further inquiries into the homeless application? I propose to start with the statutory provisions, and I have 7 points to make about the initial relief duty and the continuation of inquiries. First, there is a threshold to Part 7 provided by Section 1753. That's at Authorities Tab 1, page 3 of the Authorities Bundle.
Sorry, 1753.
3. My lord. Yes, my lord. That's at page 3, and it provides a person shall not be treated as having accommodation unless it is accommodation which it would be reasonable for him to continue to occupy. So if one imagines an application taken chronologically, this is the first consideration that would apply to such an application. Next arises the duty to make inquiries.
So I'm sorry, the risk of spelling it out, but it helps me. That question from whether a person has accommodation might perhaps plug in later in the inquiry, but essentially it's concerned with the question of whether they are homeless in the first place.
Yes.
And just to be clear, you're framing this by reference to the relief duty, and the precondition of the relief duty is that the local housing authority is satisfied that an applicant is homeless and eligible for assistance. So where Section 175 comes in is that you won't be satisfied that you may be satisfied that the person is homeless because the accommodation they're in is not accommodation that it would be reasonable for them to occupy.
Yes, my lord. So Section 1753, reasonable to continue to occupy, can apply in cases where somebody is homeless at home, for instance.
Yes.
So they would still...
So it's a consideration that you take into account when deciding on whether one of the preconditions of Section 189B is satisfied.
No, the language is ever so slightly different when it comes to Section 184, duties to make inquiries, and Section 188, duty to provide interim accommodation, versus those 2 duties that arise under 189A and 189B, where you are satisfied that an applicant is homeless. But this threshold criteria at 1753 applies when a person first approaches a local authority and claims to be homeless.
And I followed that, but as I understood it, what you were doing was relating the relief duty to other matters. And the precondition of the relief duty is that the authority is satisfied that the person is homeless. Now, plainly, one thing they have to bear in mind in that context is Section 1753. You can be homeless even though you've got accommodation. But does it go beyond that in the context of Section 189B? It's something you bear in mind when deciding whether the precondition is satisfied.
It must be borne in mind because it is the only definition of homelessness that's provided under Part 7. So yes, my lord, it is a factor that must be considered. Later in my submissions, I'll explain why it's important to consider accommodation, the suitability of accommodation relative to the amount of time that a person might be expected to spend there, and that relates to this definition and how it's operationalised in practice. I was going to come next to my second submission as to the first issue concerns a section 184 duty to make inquiries. My lord identified it as a procedural duty. It's at page 17 of the authorities, tab 1. What's noteworthy about section 188 and section 184, so section 184, the duty to make inquiries, is at page 14, I apologise, and section 188, the interim duty, is at page 17. What they have in common is that both statutory provisions use the language of a low threshold. They both begin at subsection 1 by saying, if the local authority have reason to believe that an applicant may be homeless, and then they begin to differ. The emphasis there is on a low threshold, that is, they need only to have reason to believe that an applicant may be homeless. The position changes in relation to the next two duties.
We're still on your second point here, are we?
Yes.
Yes, okay.
And my third point will take us to section
Yes.
19A. So that's
But you said when you said position change with regard to the next two duties, which are they?
the next two duties are section 19A, the duty to make an assessment, and section 19B, which I've termed the relief duty. These two duties were introduced by amendment by the Homelessness Reduction Act in 2017. They share a different threshold. We find section 189A on page 23 and section 189B on page 26. Section 189A then provides, if the local housing authority are satisfied that an applicant is homeless, you can see that the position now has changed from the authority's perspective. They're no longer at reason to believe, and they are now satisfied as to factually a person is homeless. And if they are so satisfied, the duty under 2 arises. The authority's assessment of the applicant's case must include an assessment of A, circumstances that caused the applicant to become homeless. B, the housing needs of the applicant, including in particular what accommodation would be suitable for the applicant and any person with whom the applicant resides or might reasonably be expected to reside, and C, what support would be necessary for the applicant and any other relevant person to be able to have and retain suitable accommodation. Moreover, under section 189A, assessment, there is a further provision by subsection 9, until such time as the authority consider that they owe the applicant no duty under any of the following sections of this part.
So sorry, which provision were you looking at?
Over the page, my lord. So I was on page 23, 189A.
Sorry, I'm not using the bunk because that's not very helpful, the form in which we've got it. I've got my own printout of the Act.
Oh, I see.
So, but just give me the section.
Subsection 9. So
189A9.
9. My lord, yes.
Thank you.
So until such time as the authority consider that they owe the applicant no duty under any of the following sections of this part, the authority must keep under review A, their assessment of the applicant's case, comprising those matters I've just identified by subsection 2, and B, the appropriateness of any agreement reached. So
the following sections would be 181A, 189 would be the initial duty and relevantly the main duty.
Yes.
Yeah.
My fourth point then concerns,
Oh, sorry, I didn't know. What was your third point?
my third point was about section 189A, what constitutes an assessment, so subsection 2, and subsection 9, it must be kept under review.
Yes, I see. Thank you. So sorry.
My fourth point concerns what I've termed the relief duty 189 capital B. It's at page 26 of the authorities. Now, this shares the same language as the sister provision under 189A. Here, by subsection 1, again, the local housing authority are satisfied that an applicant is homeless and eligible. This is a duty to take steps, reasonable steps, and that's provided by subsection 2. Unless the authority refer the application to another local housing authority in England, the authority must take reasonable steps to help the applicant secure that suitable accommodation becomes available for the applicant's occupation for at least A, 6 months, or B, such longer period not exceeding 12 months. Pausing there, it is in my submission important to note the upward limit, including a 12-month maximum in this relief duty phase.
May be prescribed by whom?
The Secretary of State.
Yes, I see.
There is an inclusion of a maximum. This accommodation it is envisaged is somewhere between 6 and 12 months. On the face of it, in my submission, this isn't accommodation designed to cure homelessness. It's accommodation designed to relieve it temporarily. That's why I say there's a 12-month maximum provided under the duty under subsection 2.
Well, isn't that designed to limit the extent to which the Secretary of State can impose obligations on local authorities?
Yes. Yes, my lord. Noting also that it must be suitable relative to this 6 to 12 month period envisaged.
It doesn't say, this may be something we're going to argue later, it doesn't say suitable accommodation bearing in mind it's only for 6 months. It just says suitable.
I will come to that later, my lord.
Yes.
Suitability is always sensitive to the length of time.
Right, but that's equally, yes, okay, fine.
Therefore, the section 189B duty to take reasonable steps necessarily requires a lawful assessment and plan under the previous section 189A. We know that from 189B3. In deciding what steps they are to take, the authority must have regard to their assessment of the applicant's case under section 189A. The authority which I have included at tab 19 of the bundle, UOM Redbridge, is a recent case as to the relationship between the section 189A duty and the suitability of accommodation. I will return to make submissions on that case later, but to identify now for my lords its authority for the proposition that it's not possible to take reasonable steps if there is no meaningful lawful housing needs assessment.
Sorry, you've got to say that a bit more loudly, is that
There must be a meaningful and lawful housing needs assessment under 189A for there to be suitable accommodation.
For there to be suitable accommodation.
For suitable accommodation to follow from that plan, it
That's
must be a lawful
non-sequitur,
plan.
isn't it? Suppose it is. Suppose there isn't a lawful assessment plan, but objectively it is suitable. You've still satisfied the duty under 189B, haven't you? Under 18, yes.
Well, the point.
It may be you've done it by accident or missing out a step you should have taken to get there, but if the court finds objectively that you have got the outcome intended by 189B, what does it matter that you've been in breach of the duty under 189B3?
189B requires reasonable steps to be taken, and the reasonableness of those steps must be defined by reference to the plan.
No, it doesn't say that, though, does it?
Well, the duty is to take reasonable steps.
Is this what you say Redbridge, Mr. Justice Lane said?
Yes.
So should we just look briefly at the passage? Which paragraph in that? I've got it here.
I was going to come to it a little later on, but I can find it now.
Just tell us the passage so we can, because if my lord is saying it's illogical, and you're saying it's something illogical that a judge said, let's have a look at what the judge said to see how logical it is.
Yes, my lord.
It's not binding on us, as you'll be conscious of.
No, my lord, of course, the decision of the High Court, Mr. Justice Lane, it concerned a refugee who was leaving mass accommodation with 3 children. She applied to the defendant. At paragraph 17 of the judgment, the court notes that the defendants didn't ask any questions about the housing needs of the children. At paragraph 18, there's a description of the housing plan being scant. At paragraph 20, the court notes that on the basis of the plan, various hotels were provided to the family. And then from paragraph 52, the court explains that Part 7 contains a graduated series of duties.
Sorry, I can't see that. 52.
50,
Oh, I see.
paragraph
Graduated
52.
series of duties, yeah.
Yes. And then at 57, goes on to note that the assessment under section 189A follows after the authority is satisfied that an applicant is homeless at 57. And then at 59, the court explains the initial assessment duty entails a duty to take reasonable steps of inquiry so as to be able to identify or assess potential housing needs. It's noted by reference to the code of guidance that it requires a positive and collaborative approach, ideally one featuring a face-to-face interview. The plan must, I'm at paragraph 60 now of the judgment, the plan must set out key needs that would provide the nuts and bolts for any offer of accommodation.
Sorry, which paragraph were you on?
That was 60.
60. Yes, that's
And at 61, the assessment must consider what accommodation would be suitable.
Yes. And where does he say if there isn't an assessment, they can't provide suitable accommodation?
Well, on the facts of this case, one led to the other, but I accept my Lord's point that theoretically and perhaps by accident, accommodation could be provided which was in fact suitable.
Yeah, I absolutely understand why, if you don't carry out an assessment under 189A or a proper one, you're more likely not to take reasonable steps. But I'm just saying it doesn't logically follow, and I think you're accepting that.
It doesn't follow inevitably, my Lord, yes. That's correct. But the passage from my Lord's note is at paragraphs 112 to 115. And the attendant decisions on suitability were accordingly flawed. That's at 131, because there is only unthinking and mechanistic decision making, rather than, that's at 139, sorry, unthinking and mechanistic at 139.
139.
139, my Lord. And the pro forma approach fell short of what had been ordained by Parliament. That's at paragraph 120. So the assumption is that the way that these duties will function is that the plan will do everything required of it by the statutory provision, and because it does everything required of it by the statutory provision, then accommodation is more likely to be suitable. And obviously suitability will be judged by reference to how long an applicant is going to spend in that accommodation.
Yes.
My Lord, thank you.
So is that your fourth point?
That was my fourth point. So my fifth point concerns the Homelessness Code of Guidance. It's authorities tab 2, page 95. It's the code, paragraph 13.8. The code provides...
So sorry, where in the authorities bundle did you say?
Authorities tab 2, page 95. The code provides, where homelessness is relieved, but an applicant's needs, as set out in the personal housing plan, may put them at risk of further homelessness, the housing authority should work with relevant support and specialist services to help promote sustainability. And the subsequent paragraph, 13.9, housing authorities may conduct and complete their inquiries into the duties that will be owed to an applicant under section 1932, the main housing duty, during the period in which they're attempting to relieve homelessness under section 189B.
Sorry, I missed the paragraph number.
I apologise, my lord, 13.9.
Thank you.
This is stamped archived. That's obviously, we got this one because it was the one in place at the relevant time.
My lord, yes.
Just for my note, is there new guidance which is substantively different? On these
No,
ones?
my lord, remains. 13.10 then, authorities are advised against issuing 184 decisions at the relief stage.
Just to be clear, they're advised against issuing a section 184 notification accepting the main housing duty during the relief stage.
Yes. However, we'll come on to see that actually there is a circumstance where that is likely to occur, and I'll make good on that submission in a moment, my lord.
Yeah, and you're ready to come back to explaining, which isn't immediately obvious, why the section 193 duty cannot commence until the relief duty has come to an end.
Well, that's provided for by section 193. It's one of the it's one of the conditions necessary for the main housing duty to arise. The relief duty.
We haven't come to 193 yet.
No, we haven't, my lord. Apologise, I'm jumping ahead. My sixth submission.
And sorry, just in terms of the fifth submission, we've got these 3 paragraphs. Is there any bullet point we should write out now as coming from them, or do we wait to see how you develop them?
Well, if it would assist, my lord, essentially my overarching point so far is the fact that there's a requirement to make an assessment, and the Code of Guidance, speaking as it does in those 3 paragraphs, strongly suggests, the appellant says, respectfully, that inquiries must continue during this relief duty phase of an application. For how else could steps be reasonable, and how else could accommodation be adjudged suitable at this stage?
Hard to imagine. Cases differ enormously, but there will be some cases where you make inquiries on day 1 or in week 1. They elicit everything that's likely to be relevant to your decision. You're satisfied they've elicited that. You've got clear evidence from doctors, the applicant themselves, anyone else. Of course, if there is drawn to your attention some unexpected change of circumstances thereafter, you may have to inquire into those change of circumstances. But I don't quite know what it means by saying inquiries must continue. In principle, satisfactory inquiries can be made very quickly, and there's no need to make any more unless the situation changes.
I think my lord is suggesting a situation where there's an applicant who is very clearly in priority need, very clearly eligible, very clearly homeless, and very clearly not
Not
intentionally
necessarily, but yes, go on. Yep.
If all of the necessary conditions are present for section 193 to arise, then yes, there might be no need to ever accept the relief duty.
Well,
As a matter
perhaps
of
I just haven't thought through enough how this happens. I'm not suggesting that within a few minutes you can make them all. So that the relief duty will arise in the until you've made those first inquiries. Say, so the relief duty will be present at least for a week. And if those, I see all the things that you're inquiring into. And forgive me for not having internalised this.
If it would assist, my lord, I was about to go to the main housing duty, and then we
Yes,
can see
perhaps
those
it would.
things.
Sorry, I'll keep my thoughts to myself.
No, just if it may.
No,
if it may
you're
assist.
quite right. I'm
To envisage the end point. The point of all the inquiries is to decide whether or not the main housing duty is going to arise. Essentially,
Is it limited to that? I mean, the main housing duty only arises if you've got priority need. The homelessness relief duty is not intended just to be limited to priority need.
no. And inquiries would also be needed in order for the local authority to determine what accommodation would be suitable. For instance, in discharge of the 193 duty. So no, my lord's quite right that wouldn't be the limit of the inquiries. But in terms of focusing on those conditions necessary for section 193 to be accepted, we might turn to the main housing duty. It's at page 33 of the authorities bundle.
This is your point 6.
It is. By subsection 1, on page 33, we can see those conditions which are necessary for 193 to be accepted. So a local housing authority must be satisfied that an applicant is homeless and eligible for assistance, and they must not be satisfied that the applicant became homeless intentionally, and also satisfied that the applicant has a priority need, and C, which was my lord, anticipated by my lord, the authority's duty to the applicant under section 189 capital B2 has come to an end. So pausing there just to emphasise the point, the respondent's case is that the 189B duty ending is synonymous with no housing duty, no main housing duty under 193, when in fact the opposite is true. The ending of the relief duty, the 189B2 duty, is a necessary but not sufficient condition for the 193 duty to actually be accepted.
Sorry, can you just say that again?
Yes. Section 193
Yep.
1C provides that it is a necessary condition for the main housing duty to be accepted that the 189B2 duty has come to an end.
Yes.
So the ending of the relief duty is necessary for the
You
acceptance.
don't get to the main housing duty unless the relief duty has come to an end.
Yes,
And
my
we
lord.
see in 189B circumstances in which it will come to an end.
Yes, my lord, and that's going to be my next submission.
But sorry, I interrupted you, or I didn't get down your initial submission. You said the respondent says such and such, but that's wrong. Can I just capture what you say the respondent says that is wrong?
Yes, the respondent's case appears to be that the end of the relief duty under 189B2 means that no main housing duty arises. They treat that as the same.
Is it as simple as that?
My lord.
I'll cede to my lord.
Well, I was just going to say, I hadn't thought that was exactly that position. The position was that it doesn't come to an end. Sorry, it isn't stopped from arising by the satisfaction of the 189BD duty as a matter of law, which, as you say, would be flatly contrary to the scheme of the Act, but that on the facts of a particular case, including this case, the steps taken as a result of in order to satisfy the 189B duty may have the result that 193 1A little Roman 1 is no longer satisfied.
The problem with their approach is they've treated it as one and the same.
Well, do they?
We can see it from their decision.
Well, that's
letter.
what we'll have to look, but
Yes.
you've got to interpret. If it was a proposition of law, speaking for myself, not having heard the other side, I'd have thought you were right. If it was a conclusion on the facts, it doesn't seem to me to be necessarily wrong.
Well,
Take an extreme case where you find you've got various complaints about the accommodation, but it doesn't look as though you're focusing on those. You've got really clearly suitable accommodation, which, if this is also relevant, is reasonable for them to continue to occupy indefinitely, and they've got a secure tenancy, and it's cheap and wonderful in all respects. It's a nonsense, and that occurred as a result of the reasonable steps taken under 189B2. Why, in what possible sense do you say they're homeless?
the problem comes in eliding the two, or in seeing that one automatically leads to the other.
Yes, but
But on
perhaps
the-
we're in the same place. I think you're accepting that as a matter of fact, the steps taken as a result of 189B2 could result in you not being homelessness.
They could.
They could, but you shouldn't assume that they have.
You cannot assume.
That they have, and so really what you're saying is that the thought process is gone through by the decision maker and reviewing officer here didn't just elided those steps, as you're saying.
Lord, yes.
Well, you'll have to show how that happened.
Yes.
Because
Can I just understand the legal debate between you? I mean, I quite follow you. The main housing duty doesn't arise, so the statute says, unless the 189B duty has come to an end. And we look to section 189B to see how it can come to an end. And actually there's a specific provision dealing with this in section 189B4, which says the authority is satisfied that there's a priority need, and then the duty will come to an end at the end of 56 days, blah, 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 blah. So I quite follow. You don't get to the main housing duty unless the relief duty has come to an end. I'm not quite sure how that is going to help you, because there are other circumstances in which the relief duty can come to an end without the main housing duty arising.
Yes, my lord. That's the next set of submissions. I was going to explain the three ways that the 189B duty can be brought to an end, can come to an end or be brought to an end, and the relationship to the main housing duty.
All right.
My lord's anticipated me.
This is 7.
Well, no, I was that's issue 2 actually. I was going to move on to issue 2,
what,
but
what was 7?
but
I'm very
7
tiny-minded, as you can see.
my lord, thank you.
You obviously are too. So
I was going to make a practical point, my lord, as my 7th point. In a sense, it's what my lord was saying earlier. Practically speaking, the homelessness relief duty is commonly accepted on day 1 of an application. So an applicant arrives, they make an application. Given that the 184(1)B duty to make inquiries also arises at that stage, it would simply be nonsensical to say that the relief duty being accepted meant that there was no inquiries duty under 184.
I mean, I suppose it depends on the time frame. if immediately on the relief duty arising, the local authority succeeded in securing suitable accommodation, what happens then?
Well, there's still a lower threshold for inquiries than there is for relief duty. So the implication in my submission would be that inquiries continue. They may be homeless.
But if you as a local authority have satisfied yourself that now there is suitable accommodation available, then the 1.8b threshold will no longer be satisfied with
The
1.4 threshold, because you no longer have reason to believe that they're homeless or threatened with homelessness.
Well, that would be a scenario that might be dealt with under the ending of the relief duty, which is the next point that I was going to come on to discuss.
Yes,
But
I can't follow you. If you end the duty, then the relief duty is just ended. But, well, perhaps I'll wait to hear what you say.
No, precisely, my lord. If the relief duty ends, the relief duty ends. It doesn't necessarily mean anything else, unless we can bring it under one of the 4 ways the relief duty ends. So that concludes my submissions on the first issue. My case, essentially, is that the initial relief duty phase features inquiries without more. So the second issue arising in this appeal, I said at the outset, was if the local authority is not absolved of the obligation to continue inquiries, then what's the time frame for completion of the inquiries? And we can look at the ways that the relief duty ends in order to make clear what timescales we might be looking up in terms of the inquiries. Now, it's important, therefore, to look at section 189B, which is at Authorities tab 1, page 26, to see the ways that it ends. We've seen when it applies, that's subsection 1. We've seen what the duty is, that's 2. We've seen by subsection 3 that there must be regard to the plan in the previous section. And then we come to subsection 4. Subsection 4 provides the first way in which the relief duty can end. Where the authority is satisfied that an applicant has priority need and are not satisfied that the applicant became homeless intentionally, the duty under 2 comes to an end at the end of the period of 56 days beginning with the day the authority are first satisfied, as mentioned in subsection 1.
So to spell out the obvious, what I hope is obvious, I hope I got this right, the scheme is that they're subject to obviously all this time they're trying to answer the main question.
Yes.
Under their duty under 184.
Yes.
When they come to an end and they've decided, yes, you have got priority need, no, you didn't become homeless intentionally, then they've got another 56 days when they are not necessarily another number, another 50. Say that happens halfway through after 3 weeks, so 21 days. They have then got another 56 less 21 days during which they are only under a reasonable steps obligation before the main absolute duty kicks in. Is that how the scheme is? It's really to help local authorities.
Yes, my lord.
By putting them under a less onerous obligation while they're carrying out their inquiries, providing they get on with them.
And do them with reference to the plan. And
Well, all right,
but yes.
One point at a time, yes.
Yes, my lord. That is the mechanics of the way
Yes, sorry.
subsection 4 works. So if one considers a chronology, my first, I have 3 points to make in relation to this. The first, I will make by way of an example application. if one imagines an applicant arriving, they're at the threshold criteria of Part 7, they apply, say, on the 1st of January. There's reason to believe they may be homeless, so they are accommodated under Section 1881. Then, say a week later, my Lord's point, say a week later, 7th of January, the local authority then accept that the applicant is homeless, and they accept the relief duty under 189B2.
Well, sorry, am I being slow? The relief duty won't have any application then, will it? Because they will already have been accommodated under 1881 in the example you've given.
Well, no, not necessarily, because when they first arrive, they're accommodated under 1881 accommodation, so temporary accommodation under the very initial interim relief duty. But then a different criteria.
Interim duty.
Interim duty, I apologise for the word, interim duty. Then a different set of criteria arise when they are accepting that the applicant is homeless. It's a higher threshold now. A week has passed, say, inquiries have revealed that the person is in fact homeless, the applicant is homeless, and the relief duty is accepted. That's what gives rise to subsection 1 of 189B. They are satisfied. And that's when Section 2 duty kicks in, the subsection 2 duty kicks in, the duty to take reasonable steps.
And the difference between the duty under 1881 and 189B2
is that you might already be accommodated under 188, and then the duty to take reasonable steps can be to elongate that accommodation, to alter it.
Well, there's 2 points really. In a sense, reasonable steps means it's a less onerous duty.
Yes.
But it's a less onerous duty to do something more substantive.
Yes.
Namely, be in the place for at least 6 months.
6 to 12 months, yes.
Right, let's just say 6 months.
Yes.
And has 12 months been prescribed? Is anything above
No.
6 months been prescribed? So it is 6 months for under the present regime.
Yes, it's 6 months, but by prescription could be up to.
I understand.
12 months, yes.
So,
Sorry.
So what you've got to take reasonable steps to do under 189B2 is better than 1, because 1 might be bed and breakfast.
Yes.
Probably will. So, I mean, 1 interim duty
It
probably is bed and breakfast.
Might be a homeless hostel. Yes.
Or a
ma'am.
right. Are you also saying there's a difference as to the standard of suitability? Because suitability is
Yes, ma'am.
part of the criterion under 189B2, whereas, remind me what the suitability provisions under 188 are.
It impliedly is that accommodation must also be suitable, but suitability is fact sensitive and relative.
Well,
to...
okay, but thank you. I know that, but where does where it doesn't say suitable at all, actually.
No.
In 1881. So where is the obligation that it be suitable come from?
Ali in the House of Lords.
Yes, I see.
And section 206 and 210.
Yes, but 2006 and 210 don't obviously apply here, but Ali said they did.
Yes.
Yes.
Yes, the obligation to provide suitable accommodation applies in relation to all accommodation. It must be suitable, but suitable is relative. It is the point.
So, is maybe a point you're wanting to argue. There's an obvious difference in that the 1881 accommodation may be very short term, whereas the 189B duty has got to be at least 6 months.
Yes, ma'am.
So that's one difference. You say there's also a difference in the calibration of suitability.
Yes, madam.
That's less obvious, but that's what you're going to show us.
Yes, madam.
Yes, I see. Thank you. That's sorry.
So just returning to the chronology, on the 1st of January, someone applies and they're accommodated under 188. A week passes, the authority is satisfied that they're homeless, the relief duty is accepted, and then the clock essentially begins to tick for the purposes of the way this duty can end under subsection 4. Because The duty under subsection 2 comes to an end at the end of the period of 56 days, beginning with the day the authority are first satisfied as in 1. So from the 7th of January, when they're first satisfied that the applicant is homeless.
And in priority need.
Mm,
If you look at 4A.
yes, and priority need, yes. So 56 days commences, time begins to tick on the 56 days on, say, in my example scenario on the 7th of January. At or around 26th of February then, so 56 days after the 7th. If priority need, and if not intentionally homeless, the duty comes to an end automatically. This is an automatic ending. In a scenario under subsection 4 then, the person is homeless, they are eligible, they have priority need, they're not intentionally homeless, and the duty under 2 has come to an end. Therefore, the main housing duty arises.
I followed that, provided nothing has happened between the 7th of January and the date of February. Suppose on the 31st of January, the local authority had succeeded in providing suitable accommodation. That would be a time when the Section 189B duty was still in place. And you would never then trigger the Section 193 duty, would you? Because the applicant would no longer be homeless by the time the duty came to an end.
Yes, if you could reason that any of those criteria were no longer met, so all of those conditions which I just described are all necessary. If any was no longer met because circumstances had changed, then yes, that wouldn't apply. But the overall effect of subsection 4 is that 193 kicks in after 56 days.
Presumably the scheme is, the 56 days must have a point. Presumably the idea is that during the 56 days, the local authority might succeed in finding suitable accommodation, and then you don't trigger the Section 193 duty at all.
Well, another way, the 56 days is in my submission to make inquiries, because at the end of that 56-day period, the duty is going to be different. If at the end of 56 days, all of the conditions necessary for 193 are present, then there is an immediate duty to provide accommodation that's suitable to the discharge of 193, which is onerous. So in my submission, the local authority uses those 56 days to make inquiries as to what happens next.
But what if it doesn't need the 56 days, is my Lord's point? What if after 30 days it has completed all its inquiries and found suitable accommodation? Then 193 wouldn't kick in, would it? Couldn't.
Well, then in my submission, that would be the territory of subsection 9, the other way that this duty can end, and I am going to come to that.
Okay. Well, can I just pursue this a moment longer? You say you need to make further inquiries, but for Section 189B(4) to kick in, the local authority must already have satisfied itself that there's priority need and that that you're not intentional in the territory of intentional homelessness. So on the face of it, you'd think, well, we'll go straight to Section 193, but the statute doesn't say that. It says we're going to defer Section 193 for another 56 days. Now, that doesn't obviously make sense that that's to make further inquiries. One would think that that's more likely to be, well, to give them a chance to achieve an end under Section 189B.
It could be, 56 days is the amount of time provided for under the review regulations, the 2018 review regulations. It's an amount of time, therefore, that one might infer is reasonable for a local authority to make inquiries and to find accommodation.
Quite. So if they succeed at day 55 in finding accommodation, then you never get to 193.
They would still need to discharge the relief duty, because unless they took a step to end the relief duty, they would, yes, 193 would be avoided as long as they considered suitability sufficiently for whatever period of time that accommodation was being provided.
Ms. Murray, the problem with this analysis is that it is entirely fact sensitive. So there may be literally hundreds of different fact situations that would give rise to a different incidence of the duties arising and being discharged. So having a sort of general conversation about the way this works is quite useful, but if it's aimed at our having to say that there is no circumstances in which the relief duty can be discharged without the main housing duty coming into effect, is utterly pointless, because it'll all depend on the circumstances. I mean, if they're put up in Buckingham Palace on day 3, obviously one situation would arise. If they're not, and there are endless other different circumstances arising at different times within the timescale set down by the legislation, then a different scenario of duties would arise. So I find it very useful to look at how these pieces of legislation interact. But ultimately, we have to look at what you're saying about your client and how these duties apply to your client in the circumstances that pertained to her. And it's only if you can show that the local authority in this case has failed to comply with its duties to your client that we're going to be, you're going to have any likelihood of succeeding in either appeal.
Yes, my lord.
And so, you know, whilst it's all very interesting for everybody to speculate on what fact situations might arise, it's already obvious to me, and I don't claim to be an expert in this area of law, that there will be situations where the relief duty arises and is satisfied, and the main housing duty never arises. And there will be situations where the relief duty arises and is discharged, and the main housing duty does arise. Of course there will.
Yes.
But I don't think that this court can give judgment about an endless range of combinations and permutations.
No, my lord, and I wouldn't invite this court to do that. My point about the relief duty is that it can accommodate, exactly as my lord says, a whole range of different scenarios whereby applicants are accommodated in all different manners. But the point I additionally make is, whilst subsection 9 of the relief duty section provides for, and I'll come to
Provides
court.
other situations in which it can be brought to an end.
You were saying there are 4 ways in which it ends.
There are three ways in which it can end. It can end
What's
by
the other 2 briefly?
it can end by 4, by subsection 4,
Yeah.
and it can end by the relationship between 5 and 7. So there's a list provided by subsection 7 of ways that the relief duty can end.
Yeah.
And then it can end by 9. And 9 is the only one. Well, 4 is automatic. 5 and 7 depend on notice being given and a list being satisfied. Well, one of a number of different options being satisfied. And then 9 expressly disapplies the main housing duty. So it's an express link to the main housing duty.
Well, I mean, 9 is lack of cooperation and refusing an offer. 56 days after determination of application, effectively under 7. And under.
Well, the 56 days is subparagraph 4, my lord. Subsection 4.
Yeah.
And then I was going to come on to 7 because 7 has different mechanics.
Just before you do, in terms of 9, you say, I think you said that disapplies the main housing duty. It doesn't, does it? It disapplies the relief duty And then section 193 disapplies them,
Yes.
the main housing duty.
I apologise, my lord, I skipped a step, but yes, that's absolutely right. It involves via 193 capital A.
Yep.
So you would, the combination of 5 and 7, which is a notice mechanism.
Yes, but if I may just on 4, just one more point on the way that this relief duty can end under subsection 4. Just to note that the Code of Guidance does provide at 1416, paragraph 14.16, which is at page 98, my Lord's note, regarding section 189B4, that housing authorities should not delay completing their inquiries as to what further duties would be owed after the relief duty, which strongly implies that the relief duty ends during which inquiries were made and someone was accommodated in accommodation for at least 6 months that was suitable for that.
Yes, but
And then,
I mean, yes, certainly, unless they're moved into Buckingham Palace. If you get my.
in which case, which was my Lord's point, but that the local authority will always have to ask themselves whether it is suitable and for what purpose.
Yes.
But yes, if an applicant was accommodated in accommodation that was suitable for the discharge of the 193 duty on the facts, then they would also be in suitable accommodation prior to that in, say, 188, if that was provided
The
as
193
188.
duty might not arise because they wouldn't be homeless, and they wouldn't be in priority need or anything else.
As long as they ask themselves the right questions,
Yeah.
then a lawful decision could be made in that way.
I mean, all I'm saying is facts make cases.
Yes, my
It
Lord.
all depends on what happened.
I will come, just to reassure my Lord, I will come to the facts. I just wish to explain the relationship between the main housing duty and the relief duty.
Can I be, so in the Buckingham Palace example, where they're put into Buckingham Palace on day 14, the way that forget the 193 duty at the moment, but the way the 189B duty ends, which presumably it would in those circumstances, is under 7, is it?
Well, it would depend on what they found as a result of their inquiry. So the code says that inquiries must continue.
Yes, but sorry, I mean, I can go over complicating it. I'm assuming all the things that the inquiries are designed to elicit have been elicited, and it is
Yes.
clear that Buckingham Palace is suitable.
Yes.
In which case, does the statute provide a mechanism to formally bring the 189B duty to an end? I think it does,
Yes.
and I assume that that mechanism is a combination of 5 and 7A.
Well, no, it's 4, my Lord. My Lord said that the conditions for 193 are met. That's what 4 provides. So the relief duty is going to end automatically 56 days after the authority was satisfied that the applicant was homeless and eligible. And meanwhile, in that 56 days, on my case, they've
Well,
been
okay, but moving that 4 will operate whether you move into Buckingham Palace or not, won't it?
yes.
So if you move into Buckingham Palace and you want to end the 189B duty before 56 days, you do it by giving notice under
5.
Under 5 and 7A, don't you?
You could say we are giving you notice under 5 and 7A
Yes.
because we have A, ended our relief duty by taking reasonable steps, and B, you now have accommodation which it is reasonable for you to continue to occupy and you are no longer homeless. The point there being that suitability has been considered in that two-stage thought process which I just described. Suitability has been considered in terms of the suitability of accommodation for the discharge of 193. So the two cannot be elided. It's not.
I dare say that comes back to the point we discussed before, but what you would do is helpfully talking us through the mechanisms.
Yes.
And in the case where you find suitable accommodation within the 56 days, and if you want to do it by the book, you might frankly not bother because at the end of the 56 days, if they're in suitable accommodation, nothing worse will happen anyway. But still, if you want to do it by the book, you give notice under Section 5. We've provided suitable accommodation for you, the West Wing of Buckingham Palace, and it's available for at least 6 months.
And it's not about them providing, it's about whether they're satisfied
Yes.
that the applicant has suitable
Yes, quite.
accommodation.
Yes, and that would discharge the relief duty, but to go on to also discharge to say that you are no longer homeless requires an assessment of...
Well, I know that's a
suitability
point you want to
different.
make, but I'm afraid I'm just being rather taking it stage by stage. You're focusing on how the 3 ways in which you can bring a 189B duty to an end. And in the example we got where you find suitable accommodation within that period, and the authority wants to bring it to an end formally, it can and should do it under 5(7)(a). And there might be other reasons. You might no longer be eligible. You may have lost your immigration status, or
Yes, that's E, my lord.
I know exactly, that's why I'm choosing it, but
Or the application is withdrawn, for instance.
exactly. But there are
Yes.
various examples here, but
Yep.
so that's the mechanism that would apply in that case.
Can I
Without
just-
prejudice to your point about you've still got to do a separate job under 193?
Yes.
So can I just be absolutely clear? The person's become homeless, the local authority is satisfied with that, and miraculously they get the person into Buckingham Palace for at least 6 months. Now there are then 2 possibilities. One is that the person had a priority need, and the other is that they didn't. If they didn't have priority need, you never get into 4 at all. If the local authority wants to terminate the duty formally, they do it under 5 and 7, as we've talked about.
That would be an option.
But even if you're within 4, if they don't want to wait 56 days, they have the option of using 5 and 7 and terminating early.
They could terminate early, yes, but they would have to make a reasoned decision as I've...
Yes.
It wouldn't be a difficult one
If it was
if there
Buckingham
was a
Palace.
lease signed by the head of the royal household saying you can stay in the West Wing of Buckingham Palace for 6 months.
Well, it would still have to be properly reasoned. But, my lord, yes. The other point that I wanted to make is sort of the opposite scenario to the one my lord identifies. My lord's talking about ending the relief duty before the 56 days. So it's going to expire anyway, under 4. But my lord wants to ask about it ending early. There's another scenario whereby the local authority might want to avoid finding priority need, and so they don't make any inquiries. And it's in that context that I introduced the case of Robinson and Hammersmith and Fulham to make the point, and this is my 3rd and final submission about subsection 4, that in my submission the duty to make inquiries does arise immediately. We've seen various sections of the code which say that, or strongly imply, that there is a duty to inquire.
Duty to make inquiries under 184.
The duty to make inquiries arises under 184 low threshold. The duty to make inquiries continues, I say, in the relief duty phase because of all the reasons that I gave under the first issue, my 7 submissions, as well as which the code at paragraph 1416 says housing authorities should not delay completing their inquiries as to what further duties will be owed after the relief duty.
I'm so sorry. I hadn't remembered. I'm sure you're very well organised. I'm sure you did make this submission. Are you saying that there is a separate duty of inquiry under 189A and B?
No, it just continues in my
I
submission.
mean, the 184 duty?
Yes,
Yes, I see. Okay.
yes. And the code
Then I
presupposes...
did understand.
But to anticipate where you're going, so just to be clear about where I think you're going, it might be said, look, in the Buckingham Palace example, you've got the person to Buckingham Palace. Buckingham Palace is going to be suitable accommodation even if you're in the main housing duty territory. You're sure they can stay there for at least 6 months. You don't have to worry about whether they're in priority need because it's become academic. That, I assume, is what you're going to take issue with. But it might be said, well, there's no need to make inquiries as to priority need once you know that the solution has already been found.
if you know the solution has already been found and you reason a decision to that effect in order to bring an end to the application under Part 7, that's theoretically possible. It is, however, a case that is remote in most scenarios. Most scenarios will require a local authority to establish whether somebody is in priority need, because housing being scarce, if there are requirements to be met for the main housing duty to be engaged, the local authority will want to know in most scenarios whether they have been met. There simply isn't an excess of suitable accommodation. In fact, the opposite is true.
And that's obviously true. But the Homelessness Reduction Act was designed to ensure that local authorities came in and helped people regardless of whether there was priority need. If their efforts succeed in solving the problem, well, why should they care about whether there's priority need or not?
Well, they would still have to they would still have to make a lawful decision. But I agree with my lord's point. Yes, there is potential for relieving homelessness and doing very little else but making a reasoned decision. However, the point in Robinson and Hammersmith and Fulham, and that's 2006 decision of this court, is that an authority can't postpone making a decision or defer an obligation to make inquiries in the hope of reducing their duties. So, whilst the advantage of the relief duty is exactly as my lord says, potentially, that doesn't mean that the 56 days can be spent making no inquiries whatsoever as to priority need in order to avoid finding priority need. That would be unacceptably to attempt to rely on one's own legal wrong. Lord Justice Waller at 36, 37 and Lord Justice Jacob at 43 are the relevant paragraphs of the decision, and if my lords want to look at it in any detail, we can. It was a case where a 17-year-old approached the local authority as homeless, and the local authority deferred making a decision about priority need until she turned 18 in order to find that she wasn't in priority need.
But that's obvious in a way. The only legal question we're really concerned with is those, and it seems obvious also to me that there are two obligations on the local authority, one under 189A to make a plan, and one under 184 to make inquiries, and both of those have specific conditions that have to be fulfilled once they are triggered. And you're saying once they're triggered, simply that the applicant moves into Buckingham Palace does not necessarily absolve the authority of concluding their inquiries and complying with those two sections. And if that's what you're saying, I don't disagree at all, anyway, speaking only for myself and at first sight. Obviously, once the duty is triggered, they must comply with their obligations thereunder.
Yes.
But equally, that does not necessarily signify that a main housing duty will always arise in such situations, because it will only arise if the main housing duty under Section 193 is also triggered. And once the person is living permanently in Buckingham Palace, there is no homelessness.
Yes, my lord.
So it's cases and cases again, which is why I keep on saying, let's look at the facts.
Yes, my lord, I did plan to make one or two other submissions on the way that the Act operates, and then go to the facts.
Yes, okay.
Thank you.
Anyway, Robinson is obviously right. Can't defer making a decision just in the hope that somebody will become 18. You obviously. Yeah.
Yes. Those are my submissions as to the way that subsection 4 of the relief duty works. I can be relatively brief about the way that 5 and 7 operate. My Lord's already anticipated. My point here is that there's a list provided by subsection 7 which describes how the relief duty ends. There's no indication in my submission from the list that it simultaneously is the case that the main housing duty ends. That would require a separate set of thought processes and questions and a decision, a reasoned decision.
Sorry, I'm not sure I do follow that.
Well,
if you've brought the duty to an end under section 189B, 5 and 7, then you may or may not find that you're in section 193, depending on whether the conditions of section 193 are satisfied.
yes, my Lord. But they're not one and the same automatically. The ending of the relief duty doesn't automatically mean there's no housing duty, is my only point.
But if you have brought the duty to an end on the basis that there's suitable accommodation, and that is going to last for at least 6 months, you're not going to get into 1931 because the applicant isn't homeless.
If you have concluded that that accommodation is suitable to cure their homelessness, that would be correct. But you would have to ask yourself that question. And in my submission, it would be relatively unlikely that, let's call it relief duty accommodation, would be so suitable as to cure homeless, because we know from the list, for instance, A, this is accommodation that's suitable for 6 to 12 months. It is in my submission slightly awkward to read a provision for 6 to 12 month accommodation as accommodation synonymous with suitability under section 193.
Why? I don't understand.
Because accommodation capable of curing homelessness must be that which is reasonable to continue to occupy.
Yes. But the fact that it's reasonable to occupy for 6 months doesn't mean it's reasonable only to occupy for 6 months and will cease to be reasonable after 7 months. It will all depend on the facts.
Yes, but you would have to ask yourself those distinct questions
Yes.
to make a lawful decision.
Can I just develop that a bit more? We've been through section 189B and so on. But is the truth that actually on your case it all turns on section 193(1) because it's a condition of 193(1) that the person is homeless? That's decided by reference to section 175. And you say for section 175, you can be homeless even if there's accommodation which it would be reasonable to continue to occupy. And I suppose that the argument goes, does it, well, the fact that the authority has concluded that there's suitable accommodation available for 6 months doesn't necessarily mean that it's reasonable for the person to occupy it.
Indefinitely, yes.
Well, it doesn't actually say indefinitely. It says reasonable for the person to occupy it. But
Yes.
is that really the only debate? Can it still be the case that a person is homeless in the sense they will be in accommodation that it's not reasonable for them to occupy, even though they're in suitable accommodation for 6 months?
Yes. They could remain homeless in relief duty accommodation, yes. They remain homeless in 188 accommodation. We have the case of Appellant that provides that. And I was actually going to come to that, so authorities tab 4. It is the case that one is homeless in 188 interim accommodation. One must be, as a matter of logic, homeless in that accommodation because one can go on to benefit from the provisions under Part 7. It's also going to be, and this is my Lord's point, on the facts, probable that someone's accommodation provided on an interim or emergency or temporary basis would not be sufficient.
Well, that's
on the
what I don't
facts
understand. You say that's by my Lord's point, you meant my point. That wasn't what I was putting to you. I'd have thought it's quite likely it will be, it may not be.
Yes.
You just don't know.
And my Lord's earlier point was that the relief duty assists local authorities. Yes, it does. Because if the relief duty encourages local authorities to provide accommodation which is suitable by reference to a plan and which is suitable for somewhere between in excess of 6 months, I say possibly maximum 12 months, but relief duty accommodation, then it is far more likely that that accommodation is going to be, in addition, suitable to cure homelessness. So the local authority is assisted by a sort of minimum standard. The 189B relief duty can be seen as introducing a minimum standard.
I must be misunderstanding you. I thought you were saying it was much less likely, I think you accepted not impossible, but much less likely that relief duty accommodation would be accommodation which it would be reasonable to expect someone to continue to occupy. And I wasn't quite sure why. The only obvious difference is that it's only available. It's available for at least 6 months, but not necessarily any more. Mm. But I'm not entirely sure whether that's a real distinction from what would be the kind of accommodation you get under 193.
Well, I think if one looks at 188 accommodation, my Lord originally said it's going to be bed and breakfast sort of accommodation, maybe a homeless hostel. That's very unlikely.
Yeah.
We would say to be suitable in discharge of the 193 duty. Then if you enter the relief duty phase and you've got accommodation which is available and suitable for at least 6 months, then it's more likely that that accommodation might also, on the facts, be suitable for an applicant to continue to occupy. And the House of Lords did mention indefinitely, but that's the definition of reasonable to continue to occupy. What length of time is a further point. But it is more likely that relief duty accommodation would be suitable for 193 than would 188 accommodation.
Oh, I see, there's sort of gradation, yes.
I mean, potentially this is a really very far-reaching submission, because 175 is not tied to section 189B. What you're saying, it's obviously the case that, because the statute says so, apart from anything else, that even though you have accommodation, you can be deemed homeless because it's not reasonable for you to continue to occupy it. But that's a long way from saying that in circumstances where you are in suitable accommodation for at least 6 months, the circumstances can be such that it's not reasonable for you to continue to occupy it.
That is my submission. Relief duty accommodation may or may not be suitable for an applicant to live in, to reside in, to continue to occupy. And the House of Lords did mention indefinitely, but without end, one might say, without foreseeable end.
So, I mean, just pursuing the indefinitely point, someone presents saying, look, at the moment I'm living in Buckingham Palace, but I'm told that in 6 months' time I'm going to have to leave. Can they say, now it's not reasonable for me to continue to occupy Buckingham Palace because I might have to leave in 6 months' time and therefore I won't be there indefinitely?
Yes, they're homeless at home.
In Buckingham Palace?
Yes, if they know they have to leave.
I mean, they might be threatened with homelessness in 6 months' time, but they're not homeless now.
Well, the relationship between threatened with homelessness and reasonable to continue to occupy is strained. That is true. And although the House of Lords does mention indefinitely, and we can turn that up, Lady Hale also makes the point that this isn't permanent. We're not suggesting that for accommodation to cure your homelessness it must be permanent accommodation, but it must be suitable for a duration that doesn't have an end, is the implication of the House of Lords decision.
Which is what indefinite means. Which is what indefinite means. Indefinite means there is no specific end.
That's what the House of Lords found in Ali.
So somebody with a 2-year tenancy in perfectly good accommodation can say, I'm homeless because I'm not entitled to stay there indefinitely.
Well, this is the problem with the concept of indefinitely. It's plainly, as my Lord said, a little fantastical when applied to a realistic factual scenario. A 2-year tenancy would cure one's homelessness, in my submission. But that isn't necessary to decide the facts of. That isn't necessary to decide this case. My lords don't have to say what. My lords don't have to definitively pronounce on what length of time would be necessary for curing homelessness. It is sufficient only to say that this is a different test. Suitability will have to be considered differently. Whether it's suitable 188 accommodation is one set of questions. Whether it's suitable relief duty accommodation is another set of questions. And whether it's suitable to discharge the 193 duty will again be a different factual, it will be a different question for the local authority.
So, the risk of getting this all wrong, does your case actually depend on saying that there is no sustainable finding that it would be reasonable for you to continue to occupy the premises that you're in?
Well, that's my case on the facts. My case on the law is that the local authority have elided the end of the relief duty.
But forget about the law
Yes.
for a moment. Do you lose unless it is the case that there is no sustainable decision that it would not be reasonable for you to continue to occupy these premises?
Not necessarily. There's still erroneous legal argument, but on the facts, I must show that it's not reasonable for me to continue to occupy this accommodation, and I secondarily make the point on the facts that it's not even suitable as relief duty accommodation, and it's not suitable as temporary accommodation.
And can I just anticipate one more thing? Going back to Section 193, where Section 193 applies, there's an obligation to provide suitable accommodation. And if you turn down suitable accommodation, the duty ends.
Yes.
Can it still be the case that you are homeless because it's not reasonable for you to occupy this accommodation, even though it's suitable, and the fact that you turn it down means that the duty ends?
My lord, if intentional homelessness is found, then you can only be intentionally homeless from accommodation which it was reasonable for you to continue to occupy. That's part of the definition of it, and that's the link between the two. So, I mean, in a sense, it's a matter of semantics, but yes, one would be, in theory, homeless and have made oneself intentionally homeless from accommodation it was reasonable to continue to occupy.
Can I just put it slightly differently? So suppose that the local authority had done all the things you say they ought to have done and had concluded that you were a priority need and therefore that the main housing duty applied, so that they had to provide suitable accommodation. And suppose that there is a sustainable finding that there is suitable accommodation. How can you be better off than you would have been had Section 193 applied?
In my lord's scenario, is there suitable accommodation which it would be reasonable to continue to occupy?
Well, suitable accommodation for the purposes of Section 193.
Then yes, that would be your best case scenario as an applicant. You would be housed in a way that cured your homelessness.
So if there is here a sustainable decision by the review officer that this accommodation is suitable to the Section 193 standard, that's that.
Yes, but that's not what the reviewer asked themselves, which is my legal point. But yes, in theory.
Well, that is why we need to come to the facts in this case.
Not only to the facts, yes, to the fact, but also to the analysis of exactly what the reviewing officer did ask themselves.
Yes, we'll come to the facts and the decision letters.
I mean, all these very interesting legal questions only arise if they arise on the facts. And, you know, I do really think we need to turn to them because the discussion does become really completely impossible to follow when you are dealing with an impenetrable number of permutations and combinations. So we do have to look at the facts of this case, and we haven't got unlimited time.
Yes, my lord. I'm grateful for the indication. My intention was to explain the mechanics of Part 7 and the way that the relief duty and the main duty linked together. I did have one or two more submissions to make. To some extent, my lords have anticipated some of what I was going to say.
Well, have you agreed how long you're going to be with Mr. Evans?
We didn't discuss it outside, actually.
Well, then let me set time limits. We do not have more than the day for this, and the day involves only another, 3 hours max. So I don't think you've already been going for an hour and 3/4. I think you really need to finish by 1:45.
Yes, my lord.
Absolute latest. So you take your own course and go at whatever in whatever order you choose. But bear in mind that anyway, speaking for myself, you are going to have to deal with the facts of this case. Otherwise, your chances of success are going to be modest.
In that case, my lord, I'm very grateful for the indication. In that case, I'll make 2 points on the law and move on to the facts.
Right.
My next point was going to be about subsection 9. I say by subsection 9, that's the way that relief duty accommodation can be provided for 6 months. Steps taken under the relief duty, accommodation is provided, and the main housing duty is avoided. I say that's what the respondent is seeking to do in this case, and that's the provision that they needed to use if they were going to do it. The reason that's important is because subsection 9 defines what's a final offer. It defines what the authority must be sure of. Well, section 193A defines it. And if the authority wanted to provide 6 months' worth of accommodation and avoid the main housing duty, in my submission, subsection 9 is what they needed to use.
I was being a little bit unfair to you when I said 1:45, because I'm happy for you to go until 2:15, obviously with an hour in between.
Oh, thank you.
Otherwise, you really have already hijacked the opportunity of dealing with the facts. Sorry, I was thinking of a case we did yesterday where we had other parties.
No, thank you. Just to make good on that submission, for the court note, at 193A, the consequences of a refusal of a final offer of accommodation at the relief stage is at page 44 of the authorities bundle. Subsection 4 of 193 capital A describes what is a final offer. It's an assured short hold tenancy. I say that's the only way that the authority could do on our facts what they wanted to do. So via 189B9 to 193 capital A, this applies the main housing duty. We know that from subsection 3 of that section. The only other...
So, kind of to be quite clear, you're saying that the only way in which, in a case of this kind, the main housing duty can be prevented from arising is that an offer of a short-held tenancy has been made and unreasonably refused.
I'm saying, no, I can't say that's the only way.
Oh, sorry, I may have misunderstood.
Perhaps I misspoke. That's the way that the authority should have dealt with this factual scenario. In my submission, that's the end they wanted to achieve. They wanted to provide 6 months' worth of accommodation, and then they wanted to disapply the main housing duty. And going under 5 and 7 led them to a situation where they avoided these safeguards under 193A, the definition of a final offer of accommodation, and elided the ending of the relief duty by the combination of subsection 5 and subsection 7A of the relief duty with the curing of homelessness without asking themselves the necessary questions as to suitability and without going through these necessary safeguards. But I think my Lord's question was, could you use 5 and 7 and then reason about suitability? And yes, theoretically, that is possible, but it isn't what was done here. And I will make good on that submission when I turn to the facts and look at the review decision. I just have one final point, if I may, about what suitability means. This is my third issue under the appeal. I said, if you conclude that an applicant's in priority need and not homeless intentionally, and the main housing duty arises, what reliance can you place on accommodation occupied during the relief duty phase? Well, suitability is relative. It is a flexible concept. What is suitable in the short or medium term is not necessarily suitable in the long term. We get that from Ali. For my Lordship's note, that's at page 141 of the authorities, which is tab 5. We know it from paragraphs 42 and 45 to 47 of that judgment.
I think we said the same in Al-Krundi, basic on Ali, didn't we?
My Lord, yes. At paragraph 18, Lady Hill makes the point that temporary accommodation does not necessarily equate to 193 suitability. So whilst it's conceivable that 188 accommodation is also suitable to discharge the relief duty and could be occupied for, say, 7 months, and inquiries might determine the point about the main housing duty, it's also possible that that accommodation would not, and the question must be asked. And then Al-Kundi is also included in the authorities bundle, that's at tab 15. It just cannot be assumed that suitability relative to one stage of the application process would be suitable overall. They are evolving requirements, was the phrase that was used in that case.
Did you give a paragraph number?
Sorry, I didn't. I've identified.
Is it Lord Justice Lewis at 81 and 82?
It's 81 to 83. I would invite the court to take note.
That's 155 in my judgment.
Yes, there's a reference to Ali at 101 and 102 and 105. Reference to paragraph 46 in Ali. For my Lord's note, at the point of paragraph 105, therefore, is that a person may be homeless for 1753, even if in suitable accommodation relative to the short term, if the authorities of the view that the accommodation would not be reasonable to continue to occupy in the longer term. They are separate questions. So the answer to the third issue in this appeal, can they rely on relief duty accommodation in discharge of the main housing duty? Well, it depends. It does depend on the facts, but it also depends on asking yourself two very separate questions. Suitability must be relative to the duty which is being discharged. We also know that suitability isn't defined. We take that from the case of Roe. That's at authorities tab 16. There is no exhaustive definition of suitability or reasonable to continue to occupy. The conceptual link is suitability relative to the time period. That's row at 31 to 34 for my Lord's note. Authority tab.
So which tab is row?
That's tab 16, my Lord. It's always going to be...
What are the para numbers?
So row at 31 to 34. And then at 37, the court notes it's a fact-sensitive assessment. The relevant facts will overlap in terms of suitability and reasonableness to continue to occupy. But they are different questions. So before moving on to the factual material that's within the supplementary bundle, just to note one final point. Al-Kundi at 83, this court found that the authority must consider with care which question they're addressing, and the decision letter must make that explicit. If I can invite my lords to turn to the supplementary bundle. The first document that we'll go to is page 163. We've seen what the High Court said in UO and the London Borough of Redbridge about plans. The document on page 163 is the covering letter by which the plan was provided to the appellant. It's dated the 15th of February 2022.
That must be wrong, mustn't it?
There's no other evidence of it having been provided. We don't know when it was provided.
I mean, there is other evidence, because if you look at paragraph 8 of page 124,
Is this the witness statement, my lord?
in the witness statement,
Yeah. Yes, it says it's provided. There's no documentary evidence and there's no email.
but they say it was provided on the 2nd of December.
It is said, but it is not said how. And there's no documentary evidence of it.
So what?
But in any event, it's not. Nothing turns particularly on that. Instead, the relevant date would be the 14th of December, which is when the decision to terminate the relief duty is dated. And in that same witness statement, which my lord was just looking at, the officer for the respondent says they sent it on the 20th of December. So this personalised housing plan, in inverted commas, page 163 is the covering letter. 164, my lords can see it's dated the 2nd of December 2021. It also says first assessment. Version of plan is silent. It was never reviewed, is my first point. It was never reviewed between its creation on the 2nd of December and the purported discharge of the relief duty by the letter dated 14th of the 12th, probably sent on the 20th of the 12th. It should have been reviewed. We've already looked at section 189A. It should have been updated. It is silent as to medical evidence. It says first assessment, and there are only 2 sentences in the box beneath the heading first assessment. It doesn't mention, for instance, the appellant's diabetes, high cholesterol, hypertension, that she's hard of hearing, that she suffers with insomnia and a heart condition. And it should say those things because in the homelessness referral form, which is dated the 3rd of November 2021, so predates this assessment by almost a month, all of those things are listed. We can see that from page 255 of the bundle.
So sorry, I'm not properly keeping up. Where you say the document at 164 doesn't mention the medical conditions.
Yes, my lord.
And I think you said where it should have done but didn't.
Well, this is dated the 2nd of December.
Yes.
Dated the 3rd of November is a document at page 255. So this information at 255 should have been in 164 if this was to be a lawful plan. Not only that, but at 157 we have a record of an interview which took place, 157 of the supplementary bundle. The date of the interview is said to be the 1st of December 2021, so that's the day prior to the plan. That also says she has no MH, no mental health presumably, advises she has physical diabetes type 2, cholesterol, high blood pressure, heart pain. So another good reason why medical evidence ought to have been in the plan and wasn't in the plan. The plan was created on the 2nd of December and the relief duty was purportedly terminated on the 14th of December by letter of that date. That's at page 170. So for my Lord's note, there is the decision saying that the relief duty has come to an end.
So which page?
170, my Lord. The relief duty has come to an end and you are no longer homeless. So between the 2nd of December and the 14th of December, well, my first submission is that the plan was inadequate because it didn't contain the medical evidence that was already before the respondent prior to the date the plan was created on 2nd. My second point is that she...
When you say it didn't contain, the plan doesn't contain the medical evidence. It doesn't,
No, it doesn't contain reference to it, my Lord. It makes no reference to
Well,
it.
why does that invalidate the plan?
Because the statute provides that it must say what her housing needs are and what support would be necessary for her to have and retain suitable accommodation.
But that depends on the assumption that her medical needs are relevant to her housing needs.
Yes.
And you say in this case they were.
Yes.
Okay.
On the 2nd of December, so the same day the plan was created, the appellant was put into accommodation which is half board. It features a service charge of £156 per month. 2 meals a day are provided. If she has a disability, a medical condition, type 2 diabetes, which affects what she can eat, at least on the face of it, that's relevant information to whether that accommodation is suitable. If you were going to put an applicant into accommodation that didn't have a service charge and didn't provide meals, then it might be arguable that her medical conditions would not be relevant. But the point is that the plan precedes the offer, as we've seen in UO, or the plan precedes the, defines what are the reasonable steps to be taken on the basis of it in discharge of the relief duty. So the plan should contain those matters which might be relevant. And I say, are on our facts relevant But in any event, on a reasonable reading of section 189A to B, would be, the medical requirements would be relevant. It says the subsection provides the housing needs of the applicant, including in particular what accommodation would be suitable for the applicant, and see what support would be necessary for them to retain suitable accommodation. So I say the plan had to contain the medical information and didn't. It also wasn't updated. It must be updated. We know that from section 189A, subsection 9, until the relief duty is discharged, and that was done on the 14th. So there were 12 days where there were material changes in circumstances. She was accommodated in a hostel during those 12 days. That's not recorded in the plan.
Well, she was accommodated and the accommodation is still in.
Yes.
Now, what was the change of circumstance?
She was accommodated on the 2nd.
But that, my lord was putting to you, that was the accommodation that was anticipated in the plan. So why is it a change of circumstances that she goes into that accommodation?
Well, because she had moved into it, my lord.
Why was that a change? Change for the better, if anything.
Well, she was in accommodation now with a service charge which she had to pay from her universal credit, and whilst the email exchange shows that the respondent thought there would be 3 meals a day provided, now there were 2 meals a day
Okay,
provided.
but it's got to be reasons like that. It's not. You were saying that the only reason to change circumstances was merely that she had moved into the accommodation that the plan was that she should move into.
Yes.
If you say when she moved in it was different from what she expected, that's a change of circumstance. But the move itself isn't. I'm not being picky. I'm just trying to get at what your real complaint is.
Well, I say that the plan should have recorded that she had moved in as a matter of procedural propriety, and also then what changes of circumstances arose from her moving in. In this case, it was not as she expected, as my lord says. But the plan is not person-centric and it is not tailor-made. We know from, if my lords are to look at the page after the covering letter, so the covering letter was at page 163, and page 164 reveals
Not person-centric or
tailored. So contrary to UO, and I appreciate what my lordship said is not a binding decision on this court, but it is indicative, I say, of what ought to be in a plan. And what we can see at 165 is contrary to that. It's just a pro forma. It's extraordinarily minimal interpretation under support needs, and there are merely boxes which are ticked, or rather crossed, but no qualitative information. It's a pro forma approach.
none of this matters unless you can point to specific things that should have been contained in it that weren't. You have done one about the medical needs.
Medical needs.
But just to say it looked very formal, that maybe there wasn't very much to say. You've got to say what there was that should have been said that wasn't.
Yes, and I say as a matter of law and as a matter of practicality, if her medical conditions had been included...
Well, that's fine. We've got that point. But apart from the medical condition, is there anything else? Is it the medical condition you're talking about?
The medical conditions, and then whether they constituted a disability, what they meant for housing needs, and what accommodation would have been suitable. Would all
Yes,
have been
all right, but
appropriate
sorry, I'm
information.
covering that all under the heading of the medical needs.
Yes.
So the fact that it's not person-centric or tailored is just a generalised comment. What you mean is it didn't take into account the fact of her medical.
Yes, and the implications, or what would be suitable. But yes, my lord, that's the point. I say the inadequacy of the plan reflects the inadequacy of inquiries, particularly the interview, and it is the appellant's evidence in her statement, that's page 178 of the supplementary bundle, that she wasn't afforded the opportunity during the interview to explain about her health or her diet.
Sorry, just give me the reference again.
I'm sorry, that's at page 178.
Yep.
The supplementary bundle. So she was placed in the hospital at the start of December, 2nd of December. Her evidence also contained in that witness statement is that she was unable to eat the food that was provided, and she quickly began to run out of funds. The consequences were described by her solicitors. She then engaged solicitors on the 19th of January. The consequences were described in her solicitor's witness statement of the hostel being, we say, unsuitable, even as temporary accommodation, and that witness statement is at pages 120 to 121 of the supplementary bundle. In particular, at 121, the solicitor explains that the service charge was £156 per month. It was only half board, provided breakfast and dinner, but did not provide lunch. So from her residual universal credit income, she had to try to provide lunch, but had no cooking facilities in which to do it, and so bought a microwave. However, she couldn't cook the sort of food that was necessary to control her blood sugar, she says. She needed to eat fish and vegetables, which she couldn't prepare using the microwave. Her blood sugar levels, she said, fluctuated, which meant that she needed to urinate more frequently. And her case was, this was accommodation which was not suitable for her, firstly because of the consequences of the service charge and the lack of cooking facilities, and secondarily because this is accommodation which is hostel format, so there are, we think, 6 to 8 bedrooms and only one lavatory. Yes, it's located close to her room, but if she needs to urinate every 20 minutes, which is her case on the facts, then the lavatory is frequently unavailable to her because it is a shared facility.
And just to be clear, by this point, the local authority has treated what it has been told as a request for a review. So all this is going to be gone into by the review officer?
Yes. These were actually, the witness statements dated the 2nd of February. The pre-action protocol letter was treated as a request for a review. The PAP is at
Just so we keep formally on the right track, because I understand you want to give us the history, but legally what you are challenging, but whether by way of appeal or by judicial review, but actually on this point by way of appeal, is the review decision.
Yes.
Yeah. So all this earlier stuff, I understand why you want to introduce it to us, but it doesn't matter if the review officer got it right and took everything relevant into consideration.
Yes, that must be right. The decision on review wasn't taken until the April, and we can come to it in due course. Just to take a little bit more of the evidence, page 174 to 177, the supplementary bundle, provides the menus. So the reason I was going to the witness statement of the solicitor was to say this witness statement was produced in pursuit of an application for permission to bring judicial review. In response, the respondent provided these menus, which we can see at 174 to 177. The menus, if examined, and I don't propose to take the court through the minutiae of the menus, but for my lordship's notes, those menus do refer to a carbohydrate and sugar heavy set of food choices. They are also very heavily caveated, my lordships will note. So the phrase not on menu before or last on menu 3 weeks ago or 4 weeks ago is often repeated throughout those menus. So the applicant's case was that the food was inappropriate. Now on review, the review decision, the reviewer did make inquiries with the GP and attempt to speak to the healthcare assistant.
And just to be clear, that followed you being sent a minded to decision.
It did, my lord.
And your solicitor's saying, why don't you make inquiries of the GP? And the review officer then makes inquiries of the GP and the healthcare.
Yes, my lord. And the healthcare assistant said, page 326, in information given on the 15th of March 2022, so approximately a month before the decision and review was made, that the appellant had been told to reduce her sugar and carbohydrate intake. So that's page 326. And my Lord's correct, and representations were made in response to, during the review process. They're dated the 1st April, and they're at page 323. Reiterating the point that the food's not suitable and there's inadequate facility for preparing food that would be suitable.
And these weren't actually your first representations, were they? I think after the Minded to decision, there had been other representations.
There were representations on the 8th of March. That's at page 304, my Lord. So this offer of or arrangement of accommodation was provided pursuant to an email exchange. Very little information was ever provided. The email exchange is at page 132 and 131. There was no tenancy agreement. No, it's actually a license because it's a single room that the appellant occupies. There was no viewing arranged, and if we look at the exchange on page 132. It is with the migrant support worker who was assisting the appellant at the time. We can see that even on the day that she moved in, on the 2nd of December, the report worker is still saying, please can you tell me what Amina can expect? How is this paid? Is there a tenancy agreement, etc.? So it's still not really understood what this accommodation is.
Where does this get you, then?
Well,
we've got to look at the position at the time of the review decision.
Well, yes, except that my submission about the review decision is that it's retrospectively attempting to justify a decision to place her in accommodation which was not at the time properly considered, and that all those inadequacies of information, the lack of inquiries, the lack of information in the plan.
That's basically a lack of good faith. You have to cross-examine the review officer, wouldn't you, to establish lack of good faith?
I wouldn't go far as to say lack of good faith, my lord. Only that.
Well, you have to look at the review decision and see whether it stands up rationally and objectively.
Yes.
To speculate that, oh well, it may look all right, but they didn't really approach it in the right way because they were trying to justify a decision already taken on inadequate basis. Theoretically, a perfectly possible ground of challenge, but it would have to be articulated as such because it is actually challenging the mindset with which the person went into the decision.
It's the flavour of the review decision is my submission.
The flavour?
The flavour of the review decision, the tenor of the review decision is one where there is a lack of information due to the urgency of the placement in early December, and we see that from the email exchange.
But I mean, this is all, if I may respectfully say so, Ms. Murray, something fairly unrealistic. I mean, if the accommodation is objectively suitable when the review decision is taken, and the review decision takes into account everything that should be taken into account at that time, she is in that accommodation, and if that is the correct conclusion, if not, obviously you have a good case, but if it is, then we're not, I mean, this is not a challenge to the process. This is a challenge to whether or not, this, as I understand it, you say this accommodation is unsuitable and it's not reasonable for her to continue to live there, for all the reasons. But if the review decision has considered everything you say and come to the conclusion you're wrong, then why does it matter that the way it came about earlier in the process, there may have been inadequate documentation or a less than complete compliance with every possible part of the route?
Well, for two reasons. The first is, even if the review decision had to be lawful as a matter of substance and not just form, and that's particularly the case in relation to disability. If there wasn't the information available, for instance, from the plan, and because the inquiries weren't made, that explains that what we see in the review decision, which is a complete, lack of engagement with whether there is a disability, the consequences of the disability, and the consequences.
I mean, that you can't just make broad statements like that when actually the review decision on its terms, I've read it pretty carefully, engages with her disability and accepts the various things.
Well, if it does that and meets the test in Hackney and Hack, then my lord would be correct.
But, are you not taking the focus the wrong way? We ought to be looking at the review decision first. You can then point to things that are wrong with it. If you think it helps your case, you can say, and it's not just that doesn't make sense. You can see it doesn't really it seems consistent with how it happened before. But approaching it by this rather laborious going through everything that happened before the review decision takes the focus off where our focus has got to be.
Well, certainly, my lord, and we can look at the review decision if it would assist the court. We can go to look at that now. It's page 110.
But the reason why it's important to do that, just to be clear, and then I will be quiet, it's important to do it because you've made about 3 statements that were broad statements that jarred immediately with me, having just read the review decision, as being inaccurate. So you said he didn't engage with the disability, or the reviewer didn't engage with the disability. Well, I can think of large numbers of paragraphs in which that did happen. So let's look at the review decision, and you say and tell us what is missing, what is wrong, and point us to the passages in the evidence that make good your submission. I mean, that's the way to do it, as my lord says.
Well, my lord, the review decision is dated the 7th of April, and that's contained at page 110 of the supplementary bundle. And I said, for instance, that the review, the decision maker in the review had made inquiries of the medical practitioner, the healthcare assistant, and I took my lords to the reference to that at page 326. However, what's missing from the review decision at, say, 22, 23, 24...
Sorry, I think you said that the review decision was in the supplemental bundle. I have the review decision in the core bundle at page 113. Is that the wrong review decision? 7th of April 2022.
The correct date?
I think it's in more than one place.
It is in several places.
Okay,
That's the same decision, my lord.
same decision. Right, now tell me where you want us to go in that.
So dealing with the menus, the reviewer says...
Sorry, which page?
Page 116 of the supplementary bundle, so paragraphs 21 onwards.
Sorry, what's confusing me, mine isn't in the supplementary bundle, mine's in the core bundle. But it doesn't, it's page 116, so that's all.
Paragraph 21. The hostel manager confirmed to Victoria Pinkett.
It looks like it's page 7 of the decision, if that's my lord.
Oh, that's helpful, thank you, yes, as I'm looking. Okay, thank you.
Yes.
We've looked at the menus. The way that the reviewing officer engages with the menus here is I say, improper, because they concede, for instance, the point made in the solicitor's representations, I'm looking at paragraph 24 in particular, that the odd day there might not be an option that's considered healthy. Well, what's said is more than that, that the menus repeatedly fail to accommodate the needs of an appellant with this disability.
We just be clear? On this sort of appeal to the county court, judicial review principles apply. So we have to look not merely at whether the review officer could have made a different assessment, but whether his assessment was unreasonable. So when you say, well, you know, the review officer arrived at the wrong conclusion, that's not good enough, is it?
That it is unreasonable is precisely, it was perverse, I say, on the facts, to find that this accommodation, which the solicitor thought was 188 accommodation and still considered was not suitable, was somehow suitable to discharge homelessness, to cure her homelessness. On these facts, the menu provides food which is entirely at odds with the needs arising from the disability of the appellant.
You're not going to make that good. You say you didn't want to take us through the menu, and might be thought that we can't, it's not really an appropriate thing for a reviewing court to do. But if your point is that the evidence in the menus does not sustain that, then we've got to look at them, haven't we?
Yes, well, we can look at it in greater
Well, you
detail,
say we
yes.
can, but you've got to. You can't just make a submission like that without showing us why it's wrong.
But even if we look at them and we see that there is, for example, a meat and a vegetable option, we have to engage with the reviewer's view that whilst they couldn't cover specific dietary requirements, residents had a choice of vegetarian and meat-based meal options at dinner times and were able to swap side dishes between the options, and that included a range of salads and vegetables. Now, you know, this court is perfectly well aware of what diabetics need and what they don't need, and it's not necessary to have a menu that says you can eat salad and cheese, say, when menu A contains a cheese portion and menu B contains a salad. You can, as they say here, choose between them to fit your diabetic needs. Everybody has dietary requirements of some kind. And I just don't understand how you can say, by reference to the menus, which I happen to have looked at, that she couldn't find suitable food within them, or that the reviewer is effectively unreasonable, is reaching a conclusion that is completely unsustainable when he says that the menus provide options and you can choose between them to get a suitable diet. I mean, how can we possibly reach that conclusion?
Well, my Lordship's right, of course, as a matter of logic, but the menus, if we do look at them, and I appreciate my Lordship's indication, so page 176, if the choice is between two unsuitable options, then the fact that there is a choice is really neither here nor
He
there.
deals with that. He says if it's very occasionally a choice between two unsuitable options, he produces evidence to say diabetics should occasionally eat carbohydrate food, just not all the time. So if it's one meal, it's okay for the choice to be between, I can't remember, pizza and fish and chips.
It is pizza and fish and chips, my Lordship's correct, that's on page 176. But it isn't, the point from the menus is that it isn't just one day, that isn't an isolated incident. It appears from the menus to be repeatedly the case that either we don't know what the choice is, because
But they come with side dishes, as he says. I mean, this is an inquiry which, you know, I think it's astonishing for this court to be engaging in. But you have to satisfy a very high test, as my lord has mentioned. I mean, is that the best point, that the menus are not suitable and she can't get? I mean, this lady suffers from type 2 diabetes, is obese, as I understand, and has high cholesterol.
Yes,
Well, there are many people in that position in this country. I mean, millions. So she's not in a unique category by the suffering from type 2 diabetes and being obese and having high cholesterol. I don't understand the other things, her other problems give rise to dietary problems. So, I mean, is there something else wrong with this review?
It is unfortunate in a sense that this court is tasked with going through minute factual points, such as the menus didn't offer an adequate choice for a diabetic. I appreciate that it's not usual for this court to deal with those factual points that are usually raised under 204 in the county court. I was going to say the menu and its treatment in the review decision at those early paragraphs, early 20s paragraphs, reflects the review decision not engaging adequately with the consequences of the disability, and that's contrary to Hackney and Hack.
But I mean, the reviewer, on the face of it, absolutely is engaging with the medical conditions. Is going through saying, are they adequately catered for? It's not the case that it's ignoring them.
It's not the case that they're ignoring them, no, but the treatment of their menus is I say, unreasonable.
And he sends the minded to decision to your solicitors. They come back. He follows up those points. He gives you a further opportunity to put in more medical evidence, and you come back and say, well, we can't actually.
Well,
this sounds pretty reasonable to me.
Well, yes, I mean, my Lord has my submission on the menus. They offer choices between two unsuitable options frequently. There are days when there are no suitable options, and the reviewer concedes that. So to reach the overall conclusion on that factual evidence that those menus represent adequate catering for a diabetic is, I say, perverse. However, the additional point is what's usual in a case where a reviewing officer is analysing medical evidence is that the local authority will go to a now medical advisor and obtain a medical assessment to try to understand the implications of the medical evidence that's before them.
It depends on the nature of the condition. As my Lord said, these are very common decisions of middle-aged elderly people, middle-aged people.
Well, she's not actually. I mean, she's what, 48?
Yes.
Middle-aged. I withdraw elderly. You don't need to be he did exactly the right thing. He spoke to the healthcare assistant who had given her advice, which is pretty standard advice, which you could also get off the NHS website, as he took the trouble to find out. There's no need to have a medical expert on this sort of thing.
Now, Ms. Murray, you've received a slightly bombardment of questions, and I mean, I expect you expected that in this court when you were talking about menus and pizza and chips, but unfortunately, you perhaps have got what you expected. What I would like you to do over the luncheon adjournment is to have a think about the factual points that you want to make, because anyway, I believe it would be very useful for us to have enumerated in the way you've done with the legal questions the criticisms that you say makes this review unsustainable, and I think it does go, your points do go beyond the menus, and so it would be useful to hear precisely how you put them. I'm going to, I don't think Mr. Evans will mind if I extend yet again the time you have to do that, but if you can do it in half an hour after lunch, that would be very helpful.
Yes, my Lord.
Is that satisfactory?
Yes, thank you, my Lord.
Okay, well, we'll resume then at 2 o'clock.
Whereas if